The March 28th terrorist attack on a passenger train in Kaduna State was one incident that put the entire nation in shock and mourning, particularly regarding the number of fatalities and casualties that were recorded in the incident. 8 people were killed and 62 others kidnapped by the terrorists, who have since released the hostages in batches, beginning with the managing director of the Bank of Agriculture, Alwani Ali Hassan, followed by another set of 11, a set of 7 victims, as well as another set of 4 and 5 victims. It's a breath of fresh air for these new set of 7 victims who were released on Wednesday after spending 135 days in captivity. Among them is Abubakar Garba, who is the son of the former military administrator of Kano and Benue states. Major General Idris Garba, Abubakar was kidnapped along with his wife and 4 children.
Having spent 135 days, we regained our freedom. It's overwhelming. I'm happy and at the same time saddened because I left good people back there. 65 of us boarded the train in March 28, 2022, and we have good people, innocent people, people that hard-working people. They left their wives, they left their families back here. I was lucky, I was privileged to have my family back there, though it was traumatizing, but then at the same time, we would like to plead on the federal government to please sit down and dialogue with these people.
For this member of the negotiating team, Tukuru Mamu, the health condition of the freed victims and the remaining ones in the forest call for urgent action by the federal government.
I think it's a very important milestone in this effort, which indicates that there is no reason for government, for example, to waste time in negotiating the release of these people. There is nothing more than preserving these innocent lives, more so in a situation whereby their lives is visibly in danger. So I hope and pray that government will do as much as possible, to ensure the release of the remaining captives as soon as possible.
So far, a total of 37 kidnapped passengers have been released by the terrorists, while 27 are still in captivity. Mamu believes the federal government must intervene as soon as possible to get them released before it's too late.
Welcome back. Well, yes, Mr. Adegboruwa, Senior Advocate of Nigeria, joins us next. We're going to talk about a number of issues, largely legally speaking. Good morning. Thank you for coming on today on the program.
Good morning. Thank you for having me.
Well, yesterday, while the, I think it was 2 days ago, right, Chief of Defense Staff, that briefing that he had concerning those that have been arrested, and then thankfully we've seen some more people released from the kidnappers then. And there was a bit of confusion as to what the specifics were, who was to do what in terms of coordination. And it appeared as though, is there something I missed there? But perhaps we'll come to that. If you could start with giving us your impression about how the coordination, the efforts are, and how we are addressing this challenge, this terrorism challenge that stares us in the face in the country.
Well, maybe the best way to say is addressing a digital problem with an analog mindset is the situation we have. I listened earlier when Mr. Makinde said we have laws that cover virtually every aspect, but the problem is enforcement. There's been a lot of effort made by the National Assembly to address issues relating to terrorism, insurgency, and general violence through various legislation that have been enacted to address these issues. The latest of which, of course, is the Terrorism Prevention Act of 2022, just enacted in May of this year, where detailed efforts have been made to address and coordinate and synchronize issues relating to terrorism, banditry, insurgency, and such other acts that threaten the existence of our nation. But of course, the challenge always is implementation, because by that law, the National Security Advisor is being placed at like a brain box of coordinating security and also counterinsurgency. And so he's supposed to have a center within his office that would regulate the activities of the intelligence agencies for the purpose of gathering intelligence. Because the effectiveness of the security of any nation is anchored upon intelligence gathering. In most cases, it's about prevention. That's why that act is titled Terrorism Prevention Act. So once you are unable to gather intelligence that will inform you ahead of time that so and so will happen or likely to happen, and so you take steps towards prevention, that nation is in some challenge. So as we are presently, that office is not coordinating in the way that the law has set it up. We're supposed to have, just like INEC, when election is being conducted, you see this situation room that is set up where you can monitor what's going on in what local government, what's going on in here. And then we say before an hour, election results are out. So we're supposed to have these coordinating centers in probably all the states of the Federation, reporting to the National Coordinating Center, being coordinated by the National Security Advisor. But that's not in place at all. I don't even think the law is being implemented in any way at all because it's new. We're all used to the Terrorism Prevention Act of 2013, which is still what most security agencies are familiar with. So I think there's need for education and enlightenment on the part of the government in terms of bringing the latest developments in crime prevention, in intelligence gathering, in line with the new law enacted by the National Assembly. Otherwise, we're in a situation whereby we have sufficient law that will regulate these activities, but they are only in the paper. They are only in the letters. Implementation is still a challenge.
Which then now poses a much greater challenge. You cited the Terrorism Prevention Act of 2013. Information available says there was one in 2011 that we upgraded in 2013. In fact, I even see another one saying there was one of 2019. Whether or not that ever saw the light of day is another matter altogether. But just as you have said, it's important to note that there is such an office as the Counter-Terrorism Office, just as you cited earlier. And so we were, speaking behind the camera, wondering, in fact, one of my colleagues there wondered, wait, is there such an office indeed? As you said, the information about these things are scarce, few and far between. The question then is, it's been about 10 years since we had that office, the counterterrorism, based on the 2013 law, the 2011 law. How come we seem to have an increasing level of terrorism acts or activities despite having such an office? Is it for funding or for political will, which I've heard and I'm clearly tired of hearing? Or what exactly is the matter? How come we have such an office 10 years down the line, we're still having these issues?
We're a nation living in denial. And that denial is simply that security cannot be a federal issue. We have to look at the Constitution and take away security from the exclusive legislative list. Because this is at the core of the crisis we're having in the country. The issue of security has been centralized. Only the federal government can legislate on it. Only the federal government can formulate policies on it. But the violence happens in the local areas. The terrorism is happening in the forests, which is outside of the control of the federal government. So you see a system that it's centralized a particular policy, but the implementation then has to be within the regions, within the zones. And the governors are powerless. The people being affected by terrorism, the people who are in a position to really stand up and fight it, have no power to do so. You saw the governor of Ondo State lamenting and weeping during the Owo massacre when he was attending the federal service. He said, we know what to do. We have human beings, we have the capacity, but we don't have the power. There's no enablement. So the first thing for the National Assembly is to come to the realization that you can't regulate security at the central level. It should be taken away from the exclusive legislative list. And then the counter-terrorism system should be, deconstructed in such a way that it goes back to the regions, goes back to the states, goes back to the local government areas, and they have capacity to be able to address this. So long as somebody sits in Aso Villa, calling himself National Security Advisor, and says, I want to set up a counter-terrorism center where I can monitor what's going on in Zamfara, what's going on in Delta, that's not possible.
Is it a function, or is it a problem of the laws or the problem of the structure? There are those who date back this centralization to the post-1966 coup, and consequently everything has happened by way of a unitary or authoritarian style that we seem not to have been able to transit from 56 years down the line. So is there, because there are those who are still wondering, we tend to still be operating our democracy or our politics like it's some form of military or central system as opposed to a decentralized one. What would you say to those who say that, look, our democracy is too central because we are yet to wean ourselves from the military, history?
Well, if you look at the Constitution, Section 2, Sub 1 says that Nigeria shall be a federation consisting of states and the Federal Capital Territory. And so that federation then means that you have a central point that takes from the regions, but the power should belong to the regions. That's a federation. But in that same constitution, as you go down the line, you see the federating states losing their powers to the center in terms of security, in terms of economy, in terms of resources. So you create a federation that is run through a unitary system. And it's not strange to us, because it was Abdusalami Abubakar that brought the constitution. And it was a product of the military. And so they still have that centralized system where there's a body in Abuja called National Judicial Council that pays the salary of judges in states and appoint judges in states. You have a system whereby you want to regulate admission into even private universities, even state universities, by a body called JAMB, sitting in Abuja, dictating cutoff marks to universities that is not funding. So we live in theory to say we're a federation, but in practical, we're on a unitary system of government.
How much
and so long as that persists, these problems will continue.
How much of the powers do the states lose to security? Because we know that almost in every state you have one form of policing structure or the other, like that the neighborhood watch, the traffic control units, whichever name they call it. But yet we still don't find, there's still certain things that are missing. So if they can set up those agencies, can't that have some impact security-wise?
No, there's no security without arms. When you talk about the effectiveness of a security agency, it's its capacity to control arms. The lethal weapons, the firearms. Under the Firearms Act of 1959, imposed on us by the colonialists, only the president has power to grant license for arms. Any form of arms at all. And all manner of arms have been prohibited. You can't hold any weapon as you are, as a private citizen, not even as a governor. Under the Firearms Act, everything is prohibited absolutely. So the president will now use his discretion to determine when to grant license, even for Dane guns. So you have that system where Lagos State has neighborhood security watch, very effective within the neighborhoods. But unless there is a gun, the armed robbers don't fear neighborhood watch who only possess uniform. And the same thing with Amotekun. You had the governor of Benue State setting up his own security agency, but without weapons. And they can combat terrorists. So when you talk security, you're talking about effectiveness, and it has to do with weapons. So as long as you centralize that system whereby only the president can grant license for firearms, then you are not ready to address the issue.
You know, that raises a lot of questions as to the proposal to for people in the States to carry firearms. But let's come back to the Terrorism Act. As a follow-up to Ayo's question, if the Terrorism Act promulgates the death penalty for someone found guilty, and 10 years down the line, when we have the Kuje jailbreak, we have Boko Haram suspects who are said to have, escaped amid the jailbreak. What's the problem around prosecution? What are the loopholes there, such that is it a political will to, go the whole hog with the Terrorism Prevention Act? I hope you catch my drift.
Yes.
Yeah.
But purely, you see that under our system, Section 174 of the Constitution gives the Federal Attorney General powers for prosecution of all criminal offenses, terrorism, insurgency, kidnapping, whatever it is. And he has the power to institute those proceedings. He has the power to discontinue them. But you now see that under the Terrorism Prevention Act, the National Counter-Terrorism Center is also empowered to set up a legal team that will assemble prosecutors, assemble experts to more or less also filter intelligence and determine whether offenses are committed. So you see the duplication of powers in that regard. And so there is a challenge as to who has the power to prosecute, for instance, because DSS now file charges in court, which is not supposed to be so. I've seen lawyers from DSS attempting to prosecute insurgency in the Federal High Court.
How is it supposed
when
to
there
be
is a living Honorable Attorney General? The Attorney General is the chief law officer of the Federation. Whatever you do it through that office. He will delegate his powers to prosecutors within the DSS. He can delegate his powers to EFCC. He can delegate his powers to ICPC. But when you have a situation where agencies struggle with the person who is authorized by law, then it becomes a problem because he can't coordinate them.
Can he delegate
And so,
his
for
powers?
instance, you see that there's a Waduman who has been arrested, and we hear he's been charged to court, but you don't hear anything about it again.
Just a quick one on that. Can the person empowered by law delegate his powers?
Oh, yes. It's even there in the Constitution, Section 174, that the powers of the Attorney General can be exercised by persons working under him or to anybody he has granted fiat or delegated the powers
So
to.
could that be the reason why that happened, the DSS?
No, the DSS filed their charges in their name. They are not acting under the delegation of the Honorable Attorney General.
So, for instance, the our church attackers who have been arrested, whose jurisdiction is it to prosecute? Would it be the police or the DSS?
It's the Attorney General of the state, Ondo State.
So, if we were to delegate his powers, which
He could
agency
delegate
would
the powers to police, he could delegate the powers to DSS, or even private practitioners. We've had cases in which EFCC, when they have very, very serious cases, they call on lawyers, senior advocates, senior lawyers to assist them in prosecuting those cases. And that's what should be, in fairness, because the government can do everything.
Just a quick, this is perhaps a small one. We deliberated over this yesterday. Who has the authority to parade suspects?
Nobody has the authority to parade the suspect under our laws. And you know the word you use, suspect. So the Constitution then says that every person is presumed innocent until otherwise proved guilty. So that presumption of innocence includes that you shouldn't create a sense of bias against me in the public. Why would you parade me, for instance, if at the end of the day I'm vindicated or acquitted of that charge? There's a guilt hanging on the head of that person already in the public domain. Whatever ammunition you have, whatever arsenal you have, marshal them in your charges, in the proof of evidence, and march the person to court and conduct a quick trial. It's either he's convicted or he's acquitted. The parading of suspects in the media is totally unconstitutional.
So whether or not,
absolutely unconstitutional.
Whether or not we blur their faces or they back the camera.
It doesn't matter how you do
Even
it.
if it is done by the police.
Even the police has no right to parade suspects. You don't have such right at all. It's against the Constitution.
No, well, it's still on this terrorism, because if we don't deal with security, I was it the president that said if we don't deal with, okay, that's corruption. If we don't deal with corruption, corruption will deal with us. I want to use that in the space of security. If we don't deal with security, or insecurity is going to deal with us. So about this, anti-terrorism law and all laws around security for the nation, for states, for citizens, and all of that. Do you see, you've talked about the fact that we lack that coordination of the laws from the Office of the National Security Advisor. What needs to be done? We're building to an election, the general election at that. And what normally happens is in the build-up to the elections, there is usually that hike in insecurity and all of that. What needs to be done now to protect lives and property and ensure that people they don't just feel safe, they are safe indeed, by law and by whatever other means?
First of all, I'd like to appeal to you to refrain from repeating this phrase by the president to say that if you don't deal with corruption, because corruption is dealing with this regime presently. This regime is totally sinking in corruption. So that phrase is now anachronistic. It's no longer relevant for us. It was when the president first came and he was using it to buy public acceptance. For now, we now know that in Nigeria, corruption has dealt with the Buhari administration. You saw that Jolly Yame and Dari were just released recently. After a court had convicted them of corrupt offenses. So let's not even reference this administration in terms of corruption. Buhari is not fighting any corruption at all. Now, having said that, the challenge we have with security is the same that Jonathan had. After Buhari came into power, we saw this scandal about the Office of the National Security Advisor, money being used for election. It's still the same thing. It's until Buhari leaves office before you see the scandal. Security has become the main means of siphoning funds for us in our nation. You want to buy Tucano jets, you want to buy all manner of things. Humongous amount of money is going under the table every day in the guise of security. The governors have so much money. For instance, in Lagos State, about ₦1 billion.
For security votes?
For security. It's a security vote. And it's not, you don't account for it. You don't know what the person is doing with the money. So for me, the challenge we have to get the governors, the federal government, and the people who represent us as our leaders to perform the primary function of securing lives and property is for us to get the will to challenge them. What are you doing with the funds? So long as we keep quiet, this will continue until 2023. And maybe after 2023, when we have Tinubu or Obi or Atiku, then we continue this circle and this story will continue.
So how then does that line up with what the Vice President said recently to the military, that they should account for security expenditure?
Well, for me, when you make these statements in the media, you just then know that there is a problem. Because the Vice President is an internal person, so he should know what he's saying. So for him to say that should show you that there's a lot of problem going on within the security agencies. And so until we get to a position whereby the National Assembly can assert their authority over these security agencies, we'll just continue in this circle.
So how do we approach that? If he says that he'd like to see more accountability with military spending and things like fiscal transparency, does that then suggest that we probe or look into the activities? Because they always tell us when it comes to security issues, we have to be careful how we look at them, because you have several other people who are looking inwards to take advantage of whatever information they can against us.
I think that for me, the National Assembly is the one appropriating funds.
Yeah.
That could be used for security or any other purpose. And there are committees of the National Assembly that should be supervising these agencies, Navy, Army. So those committees should constantly interface with these security agencies to know what has happened to the fund that's been appropriated. You claim to buy so and so. Can we see it? Are they being used at all? So if the National Assembly is up and doing, we won't have this problem about people just every day sitting in office and then we cannot confront the challenges of terrorism.
How do we the people make the National Assembly accountable in that regard, because we've had a lawmaker in time past say that even the National Assembly, some National Assembly members are corrupt, that they are the beneficiaries of certain contracts, from agencies, departments, and parastatals.
The media, under Section 22 of the Constitution, the media is to bring government to account to the people. Then the CSOs, that's why they exist. It's like an alternative opposition. Otherwise, if you have a country where there's a ruling party and then there's a viable opposition, these discussions are to be taken up by the opposition political party. And I must commend SERAP in that regard. Every day, that agency is constantly calling government agencies to account, especially on economic matters and misuse or misappropriation of funds. So the media should regulate these agencies by investigating. And then the civil society organizations, the activists. I mean, that's how we brought Nigeria to where we are. Everybody should be up. But this country, this scenario where everybody is afraid or everybody is compromised, you are either a politician or so, it is not unacceptable. Our colleagues should stand up. The NBA, the media organizations, the activists, lawyers, file suit, challenge people. Let's get our country back from politicians. Enough of this.
Talking about politicians, does that then put a question mark on our leadership recruitment process? If the people who are in office to do a job are not doing it? I know that that's taking us to electoral matters, but does that put a question mark on the process? Surely. I mean, if you look at the process of bringing leaders through the primary elections, you will see that by 2023, our problems will probably have graduated in double proportions. Because virtually everybody who's emerged now, they didn't emerge through the will of the people. There are allegations about people buying candidates, allegations about primary elections being upturned. And now we have a new regime where the National INEC says we don't even recognize elections monitored by our state regs. So that process is being bastardized. That process is being compromised unless we insist that the will of the people should prevail, especially when there's an election.
Well, speaking about the states, what they can do in terms of security, some say that, look, that the IGP or the state governors can apply to the IGP for maybe not automatic grade weapons, which the law allows, Dane guns and the likes. And the IGP can actually issue licenses for those states. Can that happen?
Oh, I believe so. If there is understanding, if there is collaboration in terms of effective policing or security, there's no reason why the governor of Lagos State shouldn't have access to the Inspector General of Police to get light weapons, double-barrel guns for neighborhood watch, or even for Amotekun in the other states, or even for the southeast or south or the northern states. It depends on the collaboration between the government. So if there is seriousness in fighting insecurity, for instance, it shouldn't be a problem for a governor to obtain license for agencies set up to fight security. But you see that this thing is purely politics. The IG will not grant the license.
But
it's
only Zamfara and now Benue that have taken such step. So we're waiting to see what the feedback will be, because we haven't heard any state say we applied for as Dane gun, which the law permits, and we were denied. So up until that happens, can we then say that, look, they're playing politics with it?
When I say playing politics, it's to the extent that there's no difference generally for me between the governor of Lagos State and the Inspector General of Police. We always say that the interest of the masses is not at the heart of our leaders. Otherwise, if there is a governor who genuinely has the interest of the masses at heart, if he applies and he was denied, he will come back to his people and say, this is what has happened. But you see, for instance, if the governor of Lagos State applies for a license and the IGP denies, he won't say anything. I can tell you that. He won't come back to you to tell you so. Because he has ambition. Because his loyalty is not to the people. I'm telling you the truth. It is so you don't then think that you have a governor who probably is ready to fight the battle of security on behalf of the people. He's thinking about second term. And is responsible to people who are responsible to other people. So
so that means we should expect Governor Trump to tell the country if he's denied.
Oh yes, he should.
He's not seeking for second term.
He should. He should. Is he not going to Senate?
Mr. Adegboruwa, your quote of the Firearms Act earlier touches at the heart of the matter, because in recent times, the helplessness of the security situation has compelled commentators to call on Nigerians to help themselves. And if Nigerians want to carry as much as a Dane gun or something beneath that, maybe a cutlass, just to feel secure, but they have to go through security checks. There is a conflict of interest there. The average Nigerian now wants to protect himself. How can we help this kind of situation?
No, it's not necessary. The burden we put on the people is totally unnecessary. Because Section 14 of the Constitution says clearly that the reason why we all collectively ask some people to represent all of us is because we can't defend ourselves. There's not much I can do against a criminal or an armed robber who is armed. There's not much I can do. But we have collectively decided to be paying taxes, collectively decided to elect certain people who gave promises, and then they get to office and then the man is sleeping. I mean, we're on May 15, or May 29 rather, 2015, the president mounted the rostrum and said, I will lead the battle from the front. He's been sleeping in Aso Rock since then. He's not leading any battle. The governor of the state, Katsina, where the president comes from, every day is crying that the entire state is being taken over by bandits, to the extent that the leading convoy of the president, when he was to go on break, was attacked. And nothing's been done. We've not even arrested the people who attacked the bodyguards of the president, how much less Ayo or myself. So we have already given this mandate to people to exercise this responsibility. So we shouldn't push it back to the masses. Let the president stand up. Let the governor stand up and defend the people. They have the resources. They have the willpower. They have the law. Look at the Terrorism Prevention Act of 2022. So elaborate.
Well, we'll take a look at
they
some
should
of
put
those.
the interests of the masses beyond their own selfish interests.
We'll take a look at some of those provisions as we move further in just a moment. Join us again. Welcome back. Well, listen to the NSA. He says, well, it's not shifting the responsibility, but he did say time and again, it's a collective responsibility. So to that extent, is that to say that we all can't play a role in this?
No, unfortunately, I mean, it's like talking from both sides of the mouth, with all due respect. He says that Nigerians are tired, and that is the truth of the matter. We keep hearing stories. When these things happen, immediately a press statement will be released, and then security chiefs will be summoned, and that is the end of the story. And I think I've been following your presentations day after day on these issues. And the major point made by most contributors is to the effect that nothing is being done. Nobody is being held accountable. I mean, a prison was attacked. The president's brigade was attacked. Nobody is being held. Nothing is being said. It's just something happened and then there's silence. So that's the reason why it keeps happening. And there are allegations that people who are responsible for this are in the government. They are close to the president. They have capacity. They have the opportunity to be able to use their positions to sponsor these events. And so it's like a government that is controlled by bandits, for the bandits, and the interests of the bandits, unfortunately. Otherwise, by now, what people say is that since the attack on Kuje, at least, there should have been somebody held responsible.
Okay, now, there is one of the efforts that people make to protect themselves is, I mean, when government can't help them, it would seem, they try to resort to some form of self-help. So this whole kidnapping for ransom thing seems to have caught the attention of this Terrorism Prevention and Prohibition Act of 2022. Section 21 of that law, talks to that. Well, the subject of it is financing of terrorism. And it says a person or entity within or outside Nigeria in any manner who directly or indirectly and willfully provides, solicits, acquires, and so on, funds or other services or attempts to provide such with the intention or knowledge of having reasonable grounds to believe that it will be used in full or in part to finance a terrorist or terrorist group and all of that, commits an offense. So essentially saying anything that has to do with kidnapping for ransom is prohibited by law. No. What do you make of this?
What I make of it is that in an attempt to grapple with a particular problem, you don't then duplicate the efforts, because kidnapping is a common criminal offense that has been addressed by most state legislatures. In Lagos State, there is a law addressing that in particular. And I think the same for most other states, where now they try to impose, some say death penalties, some say life imprisonment. So what it means is that that is already a matter that's been covered by the states in terms of attempting to address the menace of kidnapping. So to that extent, that Terrorism Prevention Act is only now limited to the FCT, because you cannot apply that in Lagos State. So
generally, or with respect to kidnapping?
To kidnapping. It can only be limited by law to the Federal Capital Territory, which the federal government has control of. Because you can't legislate for Lagos State or other states common criminal issues relating to kidnapping, armed robbery, or...
But the law does not use the word kidnapping, though. It uses the word...
Kidnapping for ransom.
Yeah.
That's what it says.
So wait, if they kidnap for ransom, and then would intend to even kill the person or cause grievous bodily harm, it's referred to as common kidnapping.
Oh yes, and it can only be enforced within the FCT from the promise of that law.
But perhaps it's in the document now, even though there's a replication in other laws in other states. But perhaps it's in the document now because these crimes go hand in hand with, terror suspects and their operational approach. Hence, the need for it to have a unique approach to prosecution.
The concept of terrorism is that a message is being preached. This is what makes it different from common crime. There is a motive, there's an agenda. It's either you are rejecting a particular policy of government or you want to force a particular agenda on government. And so you terrorize them. You take hold of government equipment, you seize a train, just to say, for instance, you don't agree with particular. But for kidnapping, it's a local crime. And it's purely for financial benefit in most cases, to demand for ransom.
What if the person...
So that's the difference.
What if the person who kidnaps one is a terrorist and he kidnaps a person requesting ransom? So on that, what will that fall? And secondly, if the person or if people pay ransom to terrorists who they know that terrorists who kidnap whoever, can they be charged for financing terrorism?
Well, there's that controversy when this law came out. I mean, the person who is wearing the shoe is the one who knows what he's feeling. You can't criminalize the efforts of families who are victims to rescue their people. Look at the trained people. The Abuja, Lagos trained victims.
Abuja, Kaduna.
Abuja, Kaduna victims. Families are raising 100 million naira every day to get their people out. So whatever anybody does to rescue his person alive, you can then criminalize it. Because you cannot shift your failure to me, and then I'm trying to assist you to get out of that, and then you then punish me. Because the responsibility of bringing a victim out of the den of kidnapper is that of the government. And if you can't do that, and then families are making efforts to be able to get their people out, you can't then punish them again, because that's double jeopardy. I've already lost somebody who is in custody. That's a punishment for me as a family. And then I make effort to get the person out through my own self-effort. and then you want to punish me again. So it can't work.
But the law is already law.
Sorry.
Well, law has to conform with public policy. A law must be rational.
So,
and that's why you see the court setting aside laws every time for one reason or the other, if it's not well thought out. The purpose of law is that it must be practicable. There's a law in Nigeria prohibiting multiple marriages, but it's an unreasonable law. And so people marry themselves here and there, and you can't. So the law has to be reasonable.
Senior advocate, if the Abuja Kaduna terror attackers now, trained terror attackers, are arrested, would they be prosecuted on terrorism charges?
Oh yes, surely.
But they kidnapped.
Oh yeah, maybe like you said, that kidnapping is now, like Ayo pointed out, for a particular motive, and that we already identified these people as trying to overhaul the government. They're trying to overrun the country, to say we want a particular set of ideas imposed on others. So any other thing they do in furtherance of that motive will also be related to terrorism.
So other terror suspects in the past had been kidnapped, but it didn't lead to that ultimate signing of the death warrant. We still have them in the prisons and they're escaping. What is militating against signing that important death warrant? I mean, it will serve as a deterrent to others who are being recruited into, very quick and fast, into bandit gangs.
I think that it takes us back to the issue of culture. I think the governors, more or less, have that milk of kindness. And we have seen virtually in all states, they are unwilling to sign death warrant to execute. I mean, look at Reverend King, or the one in Lagos State here. The conviction has been affirmed by the Supreme Court so many years on now, but and that's not only all over the country. So we've tried to look at the reasons behind it, and we think it's cultural. A person doesn't want to put his hand to say, I'm the one who asked that so and so person be killed. But governance is about responsibility. It's one of the responsibilities of the office of the governor that he has to exercise that right. And if you don't want to execute them, then you don't keep them in that state of indefinite suspense, because it's also amounting to torture. Because we investigated and discovered that they keep them in separate sections. Those who have been sentenced to death are in different compartments in the prison. So early in the morning, around 5 a.m., they go near the door of their cell to listen to the footsteps of the guards, because they take them very early in the morning before anybody knows, and take them to the place where they will either hang them or shoot them. So you imagine somebody waking up every day expecting the hangman, and he's been there for 10 years, he's been there for 15 years. So at a particular time, the former president of the NBA, Dr. Adegboruwa, went to court on behalf of some of these condemned convicts who had not been executed, to say that it amounts to torture for a person to be waiting for the hangman for 10 years. And the court found in his favor in that regard. So I think the governors should excite.
What about religion? Perhaps the governors are not willing to sign
I think
so
it's
that
also
they don't
part of it.
inflame
Culture,
passion.
yes, culture and religion.
But the law is the law.
Of course. And as a governor, you already took the oath of office to discharge the law without fear or favor, without ill will or affection. So you just have to be man enough to take those responsibilities.
What are governors permitted to do under the law with respect to perhaps persons who are being shipped from one place to the other, who are then suspected to be used to carry out nefarious activities, perhaps including terrorist acts? So can the same law that applies to a citizen apply to those persons if they suspect that they're foreigners?
Well, it's a very delicate situation. And delicate in the sense that in the Constitution you have the freedom of movement, that no person shall be restricted to move from one state to the other. You can from here get up today and go to Kano. So you can't do a blanket restriction on that particular right because it's constitutional. But at the same time, the intelligence agencies can then take up the kind of exercise that's going on in Lagos State, where the governor is trying to determine the status of citizens by asking us to come and register. There's a particular agency now that is in Lagos State asking citizens to come and take a particular card to be able to determine what is your status, where do you stay. So when you get those people who are suspected to be foreigners, you need to interrogate them and investigate, for instance. But you can't do a blanket ban on movement of people because it's a constitutional right.
What about language, senior advocate? A bandit is typically a robber who is an outlaw belonging to a gang. But in line with the Terrorism Act, as we have defined earlier, is somebody that unduly compels a government to seriously intimidate a population, to destabilize or destroy political, constitutional, economic, or social structures of a country. You know, that's just defining it briefly and loosely. Haven't we reached a point where we should stop referring to those marauders who have overrun Nigeria's northwest and are pushing further down south? Stop referring to them as bandits and start designating them appropriately as terrorists so that it can also aid prosecution should it get to that point?
Yes, not just prosecution, but also the international community have different treatments that they assign to these organizations. If you are designated as a terrorist, for instance, maybe you don't have access to visa or you don't have access to certain opportunities or privileges here and there. So it is correct to say that you don't give kid gloves to treat a terrorist by referring to them rather as bandits. It's important for government to be able to give proper designation to these terrorist agencies so that the law can easily capture their status and then the international communities can also relate to them. But when you have a situation where the state, maybe in Zamfara or so, they said a particular leader or gang was given a coronation or a chieftaincy title, and up to now, nothing has happened, you know, either to the person or the person who conferred the title. So I think that this issue of religion and culture is also affecting...
He said to be a wanted man on the police wanted
list.
Oh,
yes, yes.
But we saw a policeman standing behind him.
Oh, yes.
While that event was going on.
Oh, yes. So there is no political will, in fairness. And that's the point that's been made every now and then, that the government is not willing, not that it lacks the capacity, but it's not willing to confront the insurgents.
But isn't it equally tricky for for media, for instance, to properly designate those people? Because much as the government has designated, I think, a group or two as terrorist groups, especially, for instance, we don't know what's the name of the group that's carrying out different kidnappings in different parts of the country, especially when they don't take responsibility. How do you then properly designate such people?
Well, for me, generally, the government is responsible for that designation. It's prescribed some organizations in the southeast, also in the north. So long as that prescription is on, anybody carrying on activities similar to those ones that have been prescribed, you give them the same designation.
As terrorists.
Because it's in the same series. I mean, if you prescribe IPOB, you prescribe Boko Haram, and you know what they do, unknown gunmen or whatever it is. So when activities like that happen, every now and then, you just give them the appropriate designation.
Speaking about certain laws that are loosely drafted, yesterday we took a look at Section 115 of Electoral Act 2022, and the SAN was suggesting that, well, he thought that some provisions were loosely drafted. So what would your interpretation be about that Section 115 when it has to do with candidates in political parties?
I think that the National Assembly has a responsibility to go back and look at the Electoral Act and clean it up. I must commend the initiative of the 2022 Electoral Act. It's helped us to sanitize the electoral process in at least electronic transmission of results and taking away human intervention in most cases, you know, so that has helped us, looking at Ekiti State and also Osun State. But there are a lot of provisions in the Electoral Act that needs to be redrafted because we are all human beings. So I think that the events that have happened since the promulgation of the Electoral Act has shown that the things that they thought they wanted to capture, they were not able to do so. So the responsibility of the legislator then is to go back after that first election, and then also that of Osun, and look at those sections, Section 29, Section 84, Section 115, you know, so, and then come up with an amendment that will suit the purpose and the intention for which they thought they wanted to address. Because as it is now, issues relating to double nomination, it's caused a lot of confusion. Because I think that what they had in mind was to say you shouldn't stand as a candidate in multiple elections. For instance, you don't stand as a candidate in presidential election, and then when you lose it, you go back home and fall back to become a senator or a senatorial candidate, as it were. And if you lose that, you then fall back to become a candidate for House of Assembly. But when you look at Section 115, it didn't come out exactly in that regard. It talks about nomination in the same election. Yeah. You know, so people then give it different interpretation to say presidential election is different from senatorial election. So long as it's not the same election.
And they say if I'm an aspirant.
Yes, it's different from a candidate. Yeah. So, but I think that, I mean, if you look at the commencement of Section 115, the real beginning of 115, what it describes is a person, any person. Any person. If you look at the commencement. So the other subsections would then take their interpretation from that general description, any person. Then any person will include an aspirant, it will include a candidate. That's the way I look at it. But of course, lawyers are entitled to give different interpretations.
But then again, since it touches at the office of most National Assembly members and their survival, do you think they'll be willing to initiate any amendment?
It's a legacy. It's a legacy. And that's why everybody is commending the National Assembly, because for this Electoral Act, we owe them that commendation, indeed, that they made that effort. But now that that effort is subject to confusion and multiple interpretations, they owe us a responsibility to ensure that before the 2023 general elections, they clean up this thing and come up with an Electoral Act that will meet the intention. And I think the intention is that you shouldn't allow people to risk or be prostituting. And when you try presidency, it doesn't work, the governor will run back home and try center. They should come out clearly and state it like that. They owe us that responsibility.
Okay, we'll look to see how they approach that moving forward. But we have to thank you for coming on, Mr. Adegboruwa, Senior Advocate of Nigeria.
It's my pleasure. Thank you very much.
We'll be back in a moment to get some backstory concerning, remember all those gold medals, world record-breaking performances? That's what we're talking about next. Stay with us.